All right, so continuing on with our Charter of Rights and Freedoms, we are going to be looking at Charter Section 15, which are our equality rights. So these were some very, very important rights that were often tried to be challenged when this was just our Bill of Rights. We weren't able to do them, but now that they are up in the Constitution, they are going to be able to be used. So Section 15 reads that every individual is equal before and under the law and has the right to the equal protection and equal benefit of the law without discrimination, and in particular without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. Okay, so every individual is equal before the law and everyone gets the same protection and benefit of the law. The thing to remember about our equality rights, just like any of our rights, is that these protect us from actions of the government. So we're generally looking either at law enforcement, politicians, people that work for the government, or the laws that they create being discriminatory of some ways. So this does not apply if, a random person walking down the street does or says something that's discriminatory. This is only, the Charter only protects us against equal protection under the law, against the laws that are created, and about people that enforce the laws in Canada. Okay, and it says that we have a right to have them applied equally without discrimination. So the process in which our laws are applied, the way that people are arrested and tried, also has to be free of discrimination as well. Okay, and again, it specifically lists these categories. Okay, if we take a look at these categories, you may notice a few things that might be missing based off of your understanding of discrimination now. Okay, so race would be which country you naturally come from, whether you're a Canadian citizen or not. National or ethnic origin, the color, just color is how it's worded and how it was spoken back then. Religion, age, sex would be your basically your genitalia, how you were born, and mental or physical ability. Okay, so how we know discrimination and how we know categories of these kind of things that define us. There are some things that are definitely missing here, but at the time, these were the items that were included. Okay. The Supreme Court of Canada has been challenged. Specifically, it was Andrew versus the Law Society in looking at adding additional categories to types of discrimination. Okay, and when they were challenged, the Supreme Court set out a clear definition of discrimination. So, discrimination may be described as a distinction, whether intentional or not, but based on grounds related to personal characteristics, I apologize for the spelling, of the individual or group, which has the effect of opposing burdens, obligations, or disadvantages on such individuals or group, not upon others, or which withholds or limits access to opportunities, benefits, advantages available to other members of society. So the concept of discrimination, more so than the categories that we are looking at, okay, is any time that a distinction is made based on grounds of characteristics, and that distinction either imposes a burden that doesn't exist for people of a different category, or poses an advantage for the other category that doesn't exist for this category. Okay, so if we look at discrimination on sex, if we're talking about sex, it would just be male or female that we would be looking at. So discrimination does not include just stating that someone is male or female, okay? But it would be some sort of action that would impose a burden, okay? Having additional requirements for somebody that is female, let's say to be able to defend themselves in a court of law, okay, or advantages to the other group. So a female or a male would be discriminated against if a female was given an advantage of some sort based on the fact that they are a female. Okay, and again, this is based on the laws that we have or the programs that are run by the government specifically. Okay, so that was really, really important here. Also, if we just go back to that category there, when we read through the discrimination, it does say the law without discrimination, and then it says, and in particular for discrimination of these ones. So the way that they worded it does allow for the Supreme Court of Canada to basically add extra categories, again, without changing our Constitution. Their concept of discrimination, as is clear there, is based off of categories, okay? And they went even further in a few cases that challenged it based on sexual orientation. Okay, this is one that has been challenged up to the Supreme Court and has now been included in this on the fact that the basis that they looked at had to do with the fact that it is something that somebody is born with, and that's something that somebody cannot change without excessive costs or inconvenience. Okay, and that was deemed to be true about somebody's sexual orientation. And so even though it's not written here, it has been unofficially, I guess, through common law added, through precedent, been added to this list, and other ones may be added in the future. Okay, the second part of our equality rights is a little bit of a flip, and it allows for amelioration programs. Okay, so how it reads is it says subsection 1 does not preclude any law, program, or activity that has as its objective the amelioration of conditions of disadvantaged individuals or group, including those that have been disadvantaged because of, and then it relists those same categories from before. So what this is saying is it's saying while we cannot discriminate, we cannot benefit a different category or disadvantage one of these categories in our current laws, there are allowed to be laws and programs in place that do allow for an advantage for a particular group who has historically been disadvantaged by Canada's laws, as an attempt to, in essence, make up for the wrongdoings of the past. Okay? So technically, this section basically violates the section above it. An amelioration program, what it does is it gives an advantage to a disadvantaged group. It gives an advantage to a group because they are part of that group. Okay, which would be considered discrimination to the other group that isn't included here. Okay, so for example, if there was a program that gave advantage to women being hired into the police force, okay, which is a program run by the police or by the government, okay, that would be considered technically, that would be discrimination to men because they're being given an advantage based on their sex, okay. However, if it is deemed to be an amelioration program for the requirements where it's being done because historically they have always been discriminated against and not hired, and therefore we're trying to just make up for until we get to an equal playing field and can then go forward equally without any discrimination on either sides. Okay? It's intended to improve the situation of disadvantaged individuals and groups. And again, it's meant to be somewhat temporary until it's deemed that that kind of playing field is now fully equal for them. Okay, and it's supposed to make up for past infractions and disadvantages that existed. Okay, so if you remember, one of the very first cases that we looked at was R versus Cap, which actually I believe it was in your first test. I had you look at this case where it had to do with fishermen. So Native Canadians were allowed to start fishing multiple days before the rest of the commercial fishermen that were not Native Canadian. Okay, again, this is looking at race. Okay, and we are specifically giving an advantage to one race that isn't available to another race. So per the definition, that would be discrimination to non-Native Canadians. Okay, but when challenged using Section 15 to to the Supreme Court, they said that no, this is allowed under 15.2 because it is an amelioration program. It is meant to purposely give them an advantage for all of the disadvantage that they've been given through the colonization of Canada. Okay, so there is a lot of controversy over these things being allowed, and there's a number of debates that can happen based on personal opinions. I know I once had a student whose father wasn't able to be hired to the police force, even though he was very well qualified and had been in the Army for many, many years, because there was an amelioration at that time going on for both female and visual minorities, as traditionally they have not been hired and have been discriminated against by the police force. And so I do understand that if you are in the disadvantaged group, this kind of feels unfair because, you know, you personally may not have discriminated in your life. You personally may not have let somebody down, and now you aren't technically being discriminated against. And I know a lot of people will argue too that it's just going to create more and more resentment going forward. But then there's the people on the other side who are going to argue the need for these, because if historically one group has been given an advantage, even if you technically say it's now an even playing field, it won't be, because the requirements that you might have for a job are not attainable because they've never been allowed to get the lower level jobs that would make them able to get the higher level jobs. Again, looking at jobs in the government and different situations like that. So those are some of the considerations that go into amelioration programs. We talk a lot about them in the grade 12 course. So if you're interested in that in more ways, that's definitely somewhere that we can explore them further. But for this purpose, we just want to make sure that we're understanding them and what is allowed within our charter. All right, so we are now going to be continuing on with what I call the rest of the charter. So sections 1 through 15 is really the main bulk of the charter, okay? It goes through your rights and freedoms. There are still a few more rights that continue in the rest of the charter, but the majority of what people talk about, the majority of what people challenge up to the Supreme Court of Canada with and use in our everyday lives are included in those first sections. And as you know, that section 33, the notwithstanding clause that allows our governments to make laws that do violate some of our rights, they specifically are allowed to do it that violate 2 and 7 through 15. So again, it shows you kind of what those main ones are that the government would be interacting with on a regular basis. Okay, so we're just going to summarize them. Sections 16 through 22, another big section if you want to go ahead and read it yourself. But basically this has to do with language rights. So it sets out the fact that we have 2 official languages in Canada, both English and French. Okay, and it sets out the fact that both can be used in Parliament, in communication with the federal government, and in courts established by Parliament. Okay, so any of these organizations must have the ability to interact with people in either language of their choice. Okay, our statute laws, our records, our journals of Parliament, all of them must be published in both languages. Okay, this is why in Canada we talk about it basically, if you want to work for the government, you have to speak both languages, because pretty much everything that has to do with the government, everything that has to do with our court systems, and our laws have to be done in both languages. Okay, and it specifically says the federal government must provide services in both languages at central offices and when demanded. So at central offices in our capital and at satellite offices. So if it's located in an area where most people speak English, it's fine if most people that work there are there, but there has to be a service available that if somebody asks or wants to speak French, they are able to do that. Okay, section 23 has to do with our language education rights. Okay, so it specifically talks about one situation, and then it also goes through and does the reverse. So it says in the 9 provinces and 3 territories where most people speak English. So if we think about that, that's pretty much all of Canada other than Quebec. So the 9 provinces and 3 territories where the majority of people speak English, citizens have the right to have their children educated in French, okay, the right to, not just the desire to, but the right to, if that citizen's first language is French, if that citizen received their primary education, kindergarten to grade 6, in French, or if another child of that citizen is already receiving or did receive a French education. Okay, so this is why we have a French school board in Kitchener-Waterloo. There is an all-French school that is publicly funded in Kitchener-Waterloo and throughout the country. Okay, because if anybody has their first language of French, so they maybe grew up in Quebec or France and moved here and became a citizen, they have a right to have, if they want, their child educated in an all French school. Okay, if they receive their primary education in French, okay, again, either at one of these schools in our region here, because maybe their parents or their parents' parents grew up in Quebec before moving here, so they got to have their education in French versus for that first one, and therefore their children do for the next one. Okay, or if one child has already gotten in, so again, even if none of these applied and a random citizen said, I want my child educated in French, and they applied and the school happened to have a spot for them, and their first child was able to start their education, their second child then under the charter has a right, and any subsequent ones, to be educated in French as well. This one was initially added to ensure the rights of French people, and specifically of maintaining that culture and that language throughout our country, so that the fact that it's not just like the one province, it's not going to be diminishing over time. Okay, in the reverse, Quebec has the same criteria for children to be educated in English. So in Quebec, their public education system is all French. So if you were to move to Quebec, okay, as somebody whose first language that they were taught, if your first language that was taught was English, even though you live in Quebec, you have a charter right to have your children educated in an all English school, okay? Or if you received your primary education in English, there has to be an all English school, or again, if the first child is. So the same criteria goes both ways with the opposite languages. Okay, so even though the majority of the public schools in Quebec are French, there are all English schools to meet this charter requirement. Okay, section 24 talks about the enforcement of our charter. Okay, so subsection 1 says that if your rights and freedoms have been infringed upon, you can take it to court. Basically, section 24 is showing us how to go about challenging the charter, and therefore taking it up to the Supreme Court. Okay, so all those situations where we've seen where people have brought their cases before the Supreme Court and they've then used section 1 to determine if it's allowed or not, that's been done through section 24. Okay, section 24 also teaches us that any evidence that has been collected in a way that violates or infringes on your charter rights, that evidence will be thrown out. So specifically, remember when we talked about section 8 and how if a search was done unreasonably, that would be a violation of your section 8. Section 24 is what is then used to say that that evidence cannot be included. Okay, and again, that example we talked about this morning with the drunk driver who his blood was taken before he was told he had the right to talk to a lawyer. Okay, his charter right was infringed on, so section 24 tells him that that evidence would be thrown out in his court case. Okay, continuing on, section 25 talks about protecting culture, customs, traditions, language, and other rights and freedoms pertaining to what was deemed at that time Aboriginal people that are native to Canada before it was Canada. Section 26 talks about the rights from before the charter that are not in it. So it basically says that if anything was not included in this document that people had a right to before, they still have a right to now. Okay, 27 is the interpretation of the charter is the interpretation of the charter is to be within the preservation and enhancement of the multicultural heritage in Canada. So this one is interesting. It's kind of the people that wrote it were putting it forward to future judges, saying anyone that's going to be interpreting this charter, because we know there's lots of sections that are very vague, it should be done in a way that both preserves and enhances our multicultural heritage. Okay. Section 28 specifically says all rights and freedoms are for men and women. Okay, so even though Section 15 talks about things not being, people not being discriminated against based on their sex, they specifically had it added to Section 28 that every right is for both of them. This has to do with the history of how laws are written. So when we get to the criminal code, you're going to see that there is a male language that is used. It talks about he and him when talking about anything. And so this was put into place to basically not make them have to go back and change all the statute laws that have been written down in a male-only language to say that it applies to both. Okay. Section 29 is basically stating that while the Charter of Rights and Freedoms is in the Constitution, it cannot overwrite the Constitution. The Charter of Rights and Freedoms cannot be used to need the Constitution itself to be changed, the distribution of power. Okay. Also, throughout the document, it talks about provinces only, and so 30 clarifies that by provinces we mean provinces and territories. And Section 31 says that nothing can extend the legislative power. Okay, so in our Charter of Rights and Freedoms, right in our Constitution, it basically puts a block at any politicians trying to give themselves more power than was initially allowed when the Constitution was written. Okay, Section 32 says that the Charter applies to both the federal and the provincial governments. A lot of the language in the Charter is implying the federal government only, but it's provincial as well. And Section 33, as you know, is the notwithstanding clause, which we've studied already, so we're not going to go over again. Okay, and then Section 34, it tells you how to cite the Charter. So anytime that you are doing any work and you are referencing the Charter, Section 32 tells you that you should be writing Canadian Charter of Rights and Freedoms in italices. That's how you are going to reference it. All right. So that is our Charter of Rights and Freedoms. Awesome job getting that done.